Efficient arbitration regime in India. The Union Cabinet has recently approved certain amendments to the Arbitration and Conciliation Act. These amendments are in line with the recommendations which have been approved or suggested by the Law Commission report last year in August 2014. The Union Cabinet, presided by the Prime Minister, Mr. Narendra Modi, has recently approved certain key amendments to the Arbitration and Conciliation Amendment Bill, which will be presented before the Parliament. The key amendments which have been approved to the Arbitration Act include, in relation to the interim measures, enforcement of arbitral awards, challenge to arbitral awards, the entire cost regime. I'll be giving a brief snapshot as to the key amendments which have been approved by the Union Cabinet. The Law Commission report, which came last year, had suggested certain rigorous changes to plug the loopholes in the Arbitration Act and bring it at par with the international standards to bring India and the arbitration regime in international standards so that it becomes arbitration friendly as well as it's pro-investors. The key amendments firstly include in relation to interim measures. The interim measures can be granted by courts under Section 9 of the Act as well as under Section 17 by the Arbitral Tribunal. However, the powers of the Arbitral Tribunal and that of the court are different. With the recent amendments that have been approved by the Union Cabinet, this differential nature of powers have been removed. Now, the arbitral tribunals are empowered to pass the same kind of orders as that passed by the court under Section 9 of the Act. The interesting change is there was no rule or law with respect to the enforcement of such orders. However, the new cabinet has approved an amendment which allows that such orders will have the same effect as if they were the orders of the court. Moving on, the second aspect which has been looked into by the Union Cabinet are in relation to the appointment of the arbitrators as well as disclosure by arbitrators. The appointment of arbitrator, whether it's a judicial or an administrative decision, has long been an issue of debate. The Union Cabinet has not dwelled into it, but rather has provided a time frame within which the arbitral appointment needs to be done. It has provided for a 60-day period post-service of notice for appointment of arbitrators to expedite the entire arbitral process and introduced a new subsection in Section 11 of the Act. With respect to the disclosure by arbitrators, the Law Commission report last year has suggested certain key changes to bring it at par with respect to international standards in accordance with the IBA guidelines on conflict of interest. As per the amendments which have been approved, the arbitrators are now required to make disclosure in writing in respect to circumstances which would give rise to justifiable doubts as to their independence and impartiality. The next aspect which has been looked into by the Union Cabinet is in relation to the delay. The Cabinet has approved a 6-month process or a fast-track procedure so that arbitration proceedings can be completed within a period of 6 months in accordance with international standards adopting practices like expedited arbitration. On a separate note, with respect to the challenge to the arbitral awards as well as enforcement of arbitral awards, the Union Cabinet has provided a time frame for challenge of the arbitral awards to be done within a period of 1 year to end frivolous litigation and delay in the entire arbitral process. Secondly, the entire process of providing or delivering an award needs to be completed within a period of 12 months. The Union Cabinet has introduced provisions to include that in the event an arbitration process or the award is not delivered within a period of 12 months, it can be extended only by the court if sufficient cause is shown and as an imposition or due to the delay that has been caused, fees could be deducted of that of the arbitral tribunal but not exceeding 5% for every month. Further, in the event the arbitration process or the award is delivered within a period of 6 months, the arbitrators would be entitled to additional fees. One of the natural consequences was that the minute a party files a challenge to the arbitral award, it led to a stay in the execution process. that is no longer going to be. However, the Union Cabinet has now introduced an amendment wherein an automatic stay of enforcement would not occur on an application for its challenge being filed, unless the party makes a specific application for a stay which is heard by the court and an order has been passed to that extent. There would not be any stay on the execution of the award. This would act as a deterrent and bring an end to frivolous litigation. We are yet to see the fine text of the bill to see to what extent the Law Commission report recommendations have been taken into consideration and further changes or other amendments which have been brought to the other provisions of the Arbitration Act. However, based on the press release, we note that most of the changes are in relation to domestic arbitration. We are yet to see the changes with respect to enforcement of foreign arbitral awards and what would be the change in scenario in relation to international commercial arbitration. Once this bill, the Arbitration and Conciliation Amendment Bill 2015, is introduced before the Parliament, and if passed, it will bring a lot of changes to the arbitration regime and how foreign investors look at India as a seat of arbitration, and going forward it would become a friendly and a more pro-arbitration centric approach in India. Thank you.